with that, we will go ahead and get started. The first presenter I'm going to pass it off to is Wyatt Holliday with Shoemaker, Loop and Kendrick.
Morning. I have been, my area of practice is for employee benefits, health plans and pension plans. And it's funny, I spent the first week and a half working solely on health plans, and then I spent the last week solely on retirement, just based on how the laws have come out. But what I really want to do is just give everyone just a couple of quick updates about some health plan and retirement plan changes, and especially some things that are or are not going to require amendments to your plans to change. The first thing with health plans that probably everyone has heard about at this point is that with the Families First Coronavirus Response Act, all health plans, big, small, grandfathered, non-grandfathered, have to pay for the COVID-19 or SARS-CoV-2 test at no cost share to the individual. They also have to cover any associated fees, which are things like office visit copays, any sort of equipment that you might get charged for, extra services that basically facilitate someone getting tested. And all that has to be offered to participants at $0 copay. That is likely also going to require a plan amendment at some point. If you have a standard insured plan, that'll just probably happen for you. But if you have a self-designed plan, that's something you and your advisors are going to have to do. Along with that, the COVID-19 that testing can be provided in a high deductible health plan HSA arrangement at zero copay without violating the rules of the HSA. Usually if you have any first dollar coverage that's not preventive care, that would violate the high deductible health plan HSA rules, but that has been specifically exempted. Also specifically exempted from that is the use of telehealth, call a doc services at a $0 copay to the individual. That is also allowed under that high deductible health plan HSA regime without violating those rules. And that's a big change because a lot of people I've seen historically that have high deductible health plans with HSAs have been inadvertently violating that rule because their employer thinks that the offer of telemedicine is a great add-on and relatively, a relatively expensive great add-on, but it does prior to this violate the HSA rules. Also coming up, which is not going to require a plan amendment, is that any COVID-19 vaccine or related services, certain diagnostic testing, mitigation medication, and those things are going to be required to be covered as preventive care, which means that they are also available with no copay or co-insurance to the individual. The difference there is that anything that's designated as a qualified coronavirus preventative service is going to be have to be implemented by the plan within 15 days of its classification as a preventive service. Usually a plan has the beginning of the plan year after the certification of it as a preventive service is done. So that's a much shorter window, only 15 days between approval of that as a preventive service, and health plans have to start offering it at no copay. Retirement plans too, and I realize I'm going to cover a lot of kind of technical information, so if you have questions, let me know. The three big things with retirement plans are, for plan year 2020, the government has suspended required minimum distributions, which very few of you probably do much with your own retirement plan. That's probably being handled by your record keeper, but that is something that people may have questions about. Required minimum distributions are if you are age 70 and a half or older, you have to take a certain amount of money out of your retirement plan. There's also been temporary relief from minimum funding standards for any single employer defined benefit plan. Which probably doesn't affect a ton of people, but if you have questions on that, I'd be happy to answer them. The two big things here, though, are the CARES Act allows people to take relatively significant amounts of money out of their retirement plan more easily. There's what's called well, first off, you have to be a coronavirus related distribution. So that has to be, you have to be either diagnosed with the virus, your spouse or dependent has to be diagnosed with the virus, or you have to self-certify that you have experienced an adverse financial consequence because of a list of things: quarantine, furlough, layoff, or the closing or downturn of business due to the virus. So basically almost anybody could make the argument that they have experienced some sort of negative adverse financial consequence because of the virus. If you fall into one of those categories, and like I said, almost everybody does, plans can offer up to $100,000 as a coronavirus related distribution. That is basically that waives the 10% penalty for distributions prior to age 59 and a half. Charges regular income tax on that distribution, but you can spread that over 3 plan years, or three calendar years rather, 2020, 2021, and 2022. And the individual can choose to pay that back within that same 3-year period, or put that money back into an IRA, and income tax on any money that's repaid will not be due. The final big thing is that plan loans have changed. Rather than the lesser of $50,000 or 50% of an account, participants are available to take $100,000 or 100% of the account. And any plan loan that's either in existence now or taken in this calendar year, repayments on that will be suspended for 1 year. And at the end of that 1-year period, the interest on the loan will be re-amortized over the 5-year repayment period. That was a lot, I recognize. So if anybody has questions, please go ahead and type them in. But that is my spiel.
Thank you, Wyatt. We're going to pass it over to Carrie Urrutia with Eastman & Smith.
Thanks, and good morning, everybody. I see a lot of familiar names of folks who have called in. I wish we were able to do this in person, but I'm happy we are able to provide these updates. I'm a partner at Eastman & Smith, and I focus my practice exclusively on representing employers in EEO and other types of matters. I spent the last couple of weeks, so the first part, essentially advising clients as to whether they were an essential business and could remain open. And now we're talking more about how to change the work environment. So we're ensuring appropriate social distancing, making sure that companies are making every effort to have a safe work environment. So employees who have symptoms of COVID-19 or who live with or have been exposed to someone with COVID-19 aren't coming into the work environment. So lots of questions from clients about what can we ask? What can we do? Many of our clients are taking employees' temperatures when they come into work. A couple of weeks ago, we were giving the advice, yeah, you can't do that. The EEOC says that is a medical test and that's medical information you cannot acquire. Fast forward a week later, we have new guidance from the EEOC and a request from the governor that employers do monitor employees' temperatures. And we're seeing that happen in a variety of different ways. Many of our clients are actually having employees punch in and get their temperature monitored. It's important to remember that that type of information needs to be maintained confidentially, just like any other medical information. Most of our clients seem to be going towards questionnaires or self-monitoring for employees, where employees are asked to monitor their own temperatures and are asked several questions when they come into work. Have you had a temperature higher than 100.4? Have you been exposed to anyone with symptoms of COVID-19. That has been a large part of my practice. Unfortunately, given the number of companies that either are not essential or who have limited their operations to essential employees only, looking at furloughs and layoffs, lots of questions about continuation of benefits. I have had lots of conversations with clients about how to handle salaried exempt employees. We have to be more careful when we're talking about reducing the salary or the workload of our salaried exempt folks. And that has been a source of lots of questions from clients. Certainly the CARES Act and the Families First Coronavirus Response Act, our phones have been ringing off the hook with questions. The new regulations for the Families First Coronavirus Response Act were just issued yesterday afternoon. So we're all still reviewing and digesting those, but the Department of Labor has been posting and updating questions and answers throughout the last week or so that has provided some interim guidance for our clients. For my portion of today's meeting, I'd like to focus on the EEO issues and what you can and can't ask your employees, how you treat your employees. I've had clients calling and saying, hey, can I send my employees who are over the age of 65 home? And no, the EEO laws still apply. We have the Age Discrimination and Employment Act that we need to be concerned about. As employers, we can educate our employees and let them know who the vulnerable populations may be, and encourage employees to come to us with questions or concerns they may have. And in the course of that dialogue, we may be able to come up with another arrangement with regard to telework or other potential ways to accommodate that situation. However, it's important that we're not making decisions as employers based upon what we perceive the risks to be to our employees. If we're aware that a particular employee has an underlying disorder or disease that may predispose them to COVID-19 or predispose them to complications, we can open up a dialogue with that employee, but we want to make sure that we are not excluding them from opportunities in the workplace. The EEOC has published an updated guidance that has been pretty helpful, actually. And I'm going to send Angie, after this webinar, a couple of links to documents that I think that employers who still have employees coming to work on site should be aware of. The first was updated on March 19th, and it addresses ADA issues and COVID-19. There's also an older guidance called Pandemic Preparedness in the Workplace in the ADA. This was updated on March 21st and has some updated information specific to COVID-19. The EEOC also pre-recorded a webinar that they've posted on YouTube, and I watched last night. It's a 42-minute webinar, and it has 22 questions and answers of common questions that employers are asking with some practical answers that I would encourage you to listen to. I'll review a couple of them. I think the most common question that we're getting from our clients is they want to be able to have a safe workplace, and can we let coworkers know either who's been diagnosed with COVID-19 or who has been exposed to someone with COVID-19. And the EEOC has been very clear that while you as a company can say someone in our manufacturing classification has been diagnosed with or has been exposed to, we are not permitted to identify the employee by name. And it's really important now to let supervisors know who may be getting this information before your human resources or your leadership team, that the information with regard to specific employees' symptoms or diagnoses is confidential information and can't be shared throughout the workplace. One final thing that I wanted to touch on, because we're getting some questions, and I'm certainly, welcome questions on any other EEO issues, is what are we doing about workers' compensation claims? Are we going to receive claim allegations that an employee who's been diagnosed with COVID-19 acquired the virus at work? And what is the Bureau of Workers' Compensation going to do about these types of allegations? Like many agencies, the Ohio BWC has issued some frequently asked questions, and it looks like they are at the Bureau taking the same position I have taken with our clients who are either state funded or self-insured. And that is, it's a really specific burden to prove that an employee sustained an injury or a disease in the workplace. They have to prove that there is a direct cause or link. And given the community spread we're seeing, the Bureau has indicated that in most circumstances, claim allegations that an employee sustained COVID-19 from exposure at work will not be granted. They will be denied. There will be exceptions made for individuals who have an increased hazard as a result of their job duties, nurses, direct care professionals who are treating individuals with COVID-19, where we may see an allowed workers' compensation claim. But by and large, if you have an employee allege that they may have acquired the virus at work, it's been our initial advice to initially deny those claims and see what the proof and the medical evidence shows, because it's going to be very difficult to pinpoint whether an employee picked up the virus from a shopping cart at Kroger or from a neighbor or from a coworker. So keep that in mind as we wade through these issues. That's all I have for now. Happy to take any questions you may have about things going on in your workplaces.
Okay. Thank you, Carrie. And then if you do have any supplemental material, links, anything you want to get out, we will certainly send that out in a follow-up message to all the participants today.
Great, thank you.
Next, we will pass it over to Michelle Zuro from Shoemaker Lipman Kendrick.
Hi. As Carrie kind of discussed, I'm dealing with a lot of the same issues involving employers wanting to know about how to handle their workplace. Along with what she's discussed, and I'm sure she's getting these questions too, are a lot of questions about, what do I do that's best for my business in terms of layoffs, furloughs, reduction of hours, or trying to keep people coming to work. Really, we're seeing a split where some businesses are essential and they need their workers. I have, a hand sanitizer manufacturer that's offering overtime and that's doing everything they can to get people to come to work, whereas other employers are seeing, 70, 80% reduction in their business. So you're balancing these two situations, in many cases, sometimes the same company, depending on the location. And the advice is, how do we get the employee response that we want, whether it's we want them to stay home or we want them to come to work. And with the passage of the CARES Act, the federal stimulus bill, this has been all the more complicated because in many cases, the additional unemployment compensation amount that employees are eligible to get of $600 a week is going to put them over what they make on a normal week if they were at work. So they're incentivized to stay home at this point. And for the companies that are continuing to operate and are trying to hold it together, that presents a real problem because now their employees are motivated to stay home rather than come to work when there might be work for them to do. And maybe the work's not going to last through this whole thing, but the companies need to get that work done and they need to satisfy those customers. So what I wanted to talk about was just really the creative solutions to that problem. Is there a lot of what my companies are doing are they're paying bonuses, they're paying hazard pay, an additional hourly amount. I see Carrie nodding. Yes, exactly. They are doing different, they're planning for rewards when this is all over, parties, like whatever they can to keep their employees motivated to keep coming to work, even if the unemployment might be very enticing. The other creative solution is under Ohio law, and in a lot of the states now, you can get unemployment if your hours are reduced or your wages lowered, even if you're still employed, and you can still get the federal money. So I'm saying, look, maybe you just reduce across the board instead of laying off. We're trying to look at ways to modify that. And the same thing is with the Families First Act. A lot of companies want to offer this leave. They want to make it available, but they don't want it to be the end of their business. So we're trying to figure out, well, can we come up with creative solutions? If you have two parents who are both working and they're both trying to get leave to care for the child, can you figure out a way where one of them works Monday, Wednesday, Friday, and the other works Tuesday, Thursday? So you sort of, you give them intermittent leave, and they ultimately get the 12 weeks, but at least it makes it more manageable for your business. So trying to think out of the box at this time is key, and really trying to balance all of these concerns. I had a call with a client that wants to keep paying their employees. So they're trying to offer, payments to everybody instead of getting the tax break that they would get if they went under the Families First Act and offered them leave, which is fine. So maybe the solution for them is to keep doing that and to try to get payroll protection from the CARES Act. It's a real interesting time where we're balancing relief from different government programs, but we're trying to find a way to keep the most people working, to keep business operating, to not have it all fall apart during this time. And the other part of what I really want to discuss is, as we're having these conversations, and I'm trying to do my timesheets because it's month end, and looking at my list, I have 30 calls with employers, all frantically trying to keep their employees working. And if you go on Facebook, in any group, any community group, all you hear are complaints of, my employer did this and my employer did that. And I don't think the employees know that these conversations are happening and just how much employers are struggling to keep the business afloat. And I really want to send the message that you have to communicate with your employees and tell them what you're doing, and tell them about these painful conversations that we're having. In any way, shape, we can keep people working. I don't think they realize it. And I think once they do, maybe they're going to be more motivated, those who have work to do, to come and do it. And so, I don't mean to tread on the, consultant side of the equation, but to me, it's really important to let your employees know that you care, that you want to help them through this time, that you're working with your council and you're trying to figure out the best possible solutions to keep as many people working as you can. And I think any communications you can make along this process to make them feel safe are equally as important. And Carrie raised really important issues with the EEOC and not giving away employee information. Well, I'm telling employers, look, if you have someone who's suspected to have it or has been exposed, and the first thing you should do is ask them if you can use their name. Because if they waive the right, to confidentiality and they sign a release, then you can get their name out there, and then you can give better information to your employees, and you can keep the whole workforce calm, because maybe half the people you'd be notifying didn't actually have contact with that person. And that's a way to manage through communications that otherwise could turn into panic really easily. And so, I am trying to encourage an openness in communications that not just helps morale, but also helps in people feeling safe, because so much of why people don't want to be at work is they just simply don't feel safe, and we can't discount that right now. That's a huge thing. So that's really where my conversations have been focusing, but I could talk about any other things that you might want to discuss or answer any other questions.
Okay. Thanks, Michelle. And before we move on to Tom, I wanted to ask two clarifying questions. So if an employee is laid off and you call them back, do they have to come back or lose their unemployment?
I have been telling employers that if they don't come back, they can terminate them permanently because they've been recalled and they have refused the work, or they can. And unemployment is, it sounds like from everything they're posting on their Q&As on unemployment, they're going to be pretty liberal with this, and they may still maintain their unemployment even if they refuse to come back. If it's related to the virus, especially if they have a medical certification from a doctor, supporting them, I don't know that they're going to lose their unemployment like they normally would. But from the employer's perspective, if they really need them and they don't come back, they certainly can terminate the employee. I don't know how that helps them though, if they really need them back. And so we're trying to avoid getting to that point, because sometimes they just need the skilled workers to be there. So they're trying to work with them. We'll let you have leave, but maybe come back in 2 more weeks, things like that. But if in worst case scenario, I think they could terminate, and I think they could keep their benefits most likely. I think it's up to the state in terms of what they consider a voluntary refusal of work. But in this situation, they've already said, well, even if you don't have symptoms, but you have a doctor saying you should self-isolate, you could qualify for unemployment.
I've also been telling employers, particularly when we're communicating in writing or even orally with employees, to not make specific representations about what unemployment or ODJFS is going to do. Because, I mean, we don't know what they're going to do on a regular day, but right now there are helpful questions and answers on the website, but they are changing and being updated. And, in normal circumstances, if a specific set of facts would not entitle someone to unemployment compensation, I mean, who knows with the volume of applications they're getting right now, whether someone's benefit will be granted or whether someone will actually get a benefit for having their hours reduced. So I've been putting in my communications that, the company doesn't make determinations with regard to eligibility for unemployment. That's made exclusively by the Ohio Department of Job and Family Services, and then provide the employees that we're either laying off or reducing hours with information. And there's a mass layoff number now. So if employers are contemplating reductions in force or layoffs related to COVID-19, there's some guidance on the website that you should take a look at, in a form and a number you can advise your employees of, to make it easier for them to navigate through that process. But I agree with Michelle that it's going to be very difficult to say with certainty to an employee, if you don't come back, you are not going to continue to be eligible for unemployment, because I think it's going to be very liberally granted, at least in the next few months.
Okay. And then a clarification. So if an employee has to leave due to a family member, childcare, or any other reasons related to COVID-19, does the employer still have to pay them for 2 weeks, or can they lay them off?
I think it's either or, because the DOL really clarified this in their Q&As, and the regulations, I presume they clarified even further. But if you end up doing a layoff, you're not eligible for the Family's First Act leave. You are eligible when you return to work, however, so you can still use that 80 hours later in the year through December 31st, or if they repeal the statute before then. So to me, I think it's up to the employer. And I've frankly told them, look, you need to look at it and think, now that there's that extra $600, some of these people, if you really want to help them, they might be better off unemployed at this point than taking the leave, where they'll get 2/3 pay under the leave, but they'll get maybe half from the state and then another $600 on top of that, depending on the employee situation. The unemployment might be a better option. So, for employers who are looking to just help their employees, I'm telling them, try to do the math and figure out as best as you can where they might fall in the unemployment, to figure out if it makes sense to just do a layoff.
Okay. And does the Ohio stay-at-home order qualify as a state quarantine under Reason 1? Order under FFCRA?
So I would be interested in hearing Carrie's answer to this, but but what we could discern from the Q&As is that have come out so far. And again, the regs just came out, so I'm still sort of digesting the regulations. I don't know if Carrie's had a chance to do that. But generally, I think that refers to an order personal to you, where the public health agency has said, you are a risk, you traveled, you've done this, you've done that, you need to stay home. I don't think it's just a statewide order is enough.
That was my original interpretation, and that is the advice that most of us were providing to our clients. However, I do think there is clarification that I haven't digested yet in the regs that may require another communication with employees, that the stay-at-home orders may in fact be enough. Okay. So that's definitely on my to-do list of things.
My list too.
Yeah, right.
Yeah.
Okay.
So it's a moving target. So we're trying our best here.
Everything changes hourly.
Yeah.
And then one before I move to Tom, because I don't want to get too far away from. You still there, Wyatt? Okay. Drawing from your retirement, is the first distribution a regular or hardship?
The initial $100,000 distribution up to $100,000 distribution available is a straight regular distribution. The just as you would be able to take if you were generally as you were retired. The difference is that you can take it at any age, and the penalty for taking it out prior to age 59 and a half is waived.
Okay. Okay, thank you. And now we are going to pass it over to Tom Dixon with Eastman and Smith.
Well, good morning, all. And let me start real quickly by just touching on a couple of the conversations you were just having with Carrie and Michelle. As Carrie just indicated, the regulations that came out yesterday do indicate now that the Ohio stay-at-home order, as well as the other orders across the country, will qualify under item number 1. So those businesses who are not, they're not essential businesses, and their employees are home, appear to be eligible for this new emergency paid leave. This is a change from what we've all been describing and all expecting, but it's buried in that 124 pages of guidance that was issued by the Department of Labor yesterday. I also want to go back to the unemployment issue and affirm what Carrie and Michelle were saying, that traditionally employees who refuse to come back to work can't get unemployment compensation. And in fact, the Q&A on the Department of Jobs and Family Services website makes clear that employees can't stay at home and expect to get paid. However, with the volume of claims, those claims processors are going to find it very easy just to hit the grant button, and benefits are going to be paid. So I would encourage you, if that happens, if you have an employee who just won't come to work, if you have an employee who refuses a recall and the compensation is granted, file an appeal. The level of cases, the number of cases at that next level is going to be much less than at the original application level. So you have a chance of getting those benefits stuck. So with that, let me back up and admit to all of you that I'm flailing along with you as we try to work through what's going on for the last few weeks. I love what I do because in the area of employment law, it changes constantly, but never have I encountered a time in 40 years where it changes every day. For example, the IRS came out with guidance on Tuesday, for the first time came out with guidance on Tuesday to tell us how to deal with problems that were going to arise on Wednesday. That is, Wednesday was the effective date of the law. We get the regulations from the IRS on Tuesday. The laws go into effect on Wednesday morning, and Wednesday afternoon, the Department of Labor issues 124 pages of guidance. Not entirely consistent with what the IRS issued just the day before. So we're trying to sort through not only what is new in the regulations yesterday, but how they are different than what the IRS told us. So it's 3 steps forwards, 2 steps back for everybody, lawyers and business folks alike. Those of you who are as old as I, or at least old enough to remember the movie Groundhog Day, now know what it was like for Bill Murray in that movie. Every day we just start over again. I want to just deal with 3 or 4 quick common questions that are coming up, or common situations that I'm running into. First of all, many of you are now dealing with your problem employee in the workplace who is spreading rumors about other employees, saying that, hey, so-and-so is sick, or so-and-so has symptoms, or their family is sick, their family has tested positive, and they're really stirring the pot. You want to address those people, but the challenge is to walk the fine line between containing those pot stirrers and running afoul of some of the free speech rights that they have under the National Labor Relations Act and under the Occupational Safety and Health Act. And this is especially difficult with your frontline supervisors, who oftentimes don't appreciate what kind of free speech rights your employees have. So this is going to require you to spend some time with the supervisors and managers to make sure that they're not overly aggressive. Conversations, preferably from somebody who's trained in HR, with those problem employees are going to be fine. But when we have threats, when we have retaliation, when we have folks who are reassigned or disciplined, you're going to end up in trouble much of the time if you're not careful. A lot of clients that I'm dealing with are trying to figure out how to reduce the salaries. And I'm seeing a lot of folks just send me an email saying, starting next Monday, we're going to reduce salaries by 40%. And oh, by the way, we're going to cut the hours for our salaried people by 40% as well. They're going to go from 5 days to 2 days, or 5 days to 3 days. This is going to be a gold mine of litigation for lawyers. Salary reductions can be accomplished in ways that will allow you to do what you want to do. But it is going to be very, very difficult to do it without running afoul of the Department of Labor's regulations and some court decisions. You can reduce salaries, but you're going to have to do it not for a couple of days, not for a couple of weeks, not going up and down as your business needs indicate, not reinstating the salary in 3 weeks, and then when your business drops off again in 3 weeks, cutting it again. You're not going to be able to do that. Again, it can be done, but it has to be done carefully. It has to be looked at as a long-term reduction. And the courts generally tell us long-term means a couple of months at least. So be careful with these salary reductions. It sounds like it's good for you. It sounds like it's good for the employees because everybody gets to stay on board, but you're going to end up with lawyers all over you if you're not careful with this. Another common problem that I'm seeing is supervisors who know that their employees have some chronic health issues, whether it's an epilepsy issue, a heart issue, diabetes, whatever it might be. They're aware that their employees have problems with their health. And because your supervisors are hearing constantly that these at-risk people need to be careful, the supervisors are deciding to be careful for them and either arranging for them to be laid off, choosing them when you go through reductions in force, reassigning them, changing their hours, changing any terms and conditions of their employment. That's simply unlawful. If your employee with a condition, an underlying condition, comes forward to you and says they need some assistance, you can ask them, hey, how can we help you with that? And maybe they end up asking for a layoff. Maybe they're eligible for the new emergency paid leave. Maybe they just want you to know so that if something happens, you're prepared to step in and fill in for them when they're absent. Supervisors get into trouble a lot of times for being overly paternalistic. And the best example I've seen wasn't a COVID-19 issue, but some time ago, a woman who was pregnant had had 2 prior miscarriages. Her supervisor knew of the 2 prior miscarriages. So the supervisor reassigned her for the duration of her pregnancy. The employee wasn't happy, the employee sued, and she won. What was well, 2 interesting things about that. Number one, we can't be too paternalistic. We have to wait for these folks to come ask us. But the second thing was, you can't even get away with this when the employee is your sister. Yeah, in this particular case, the supervisor was the sibling of the woman who was pregnant. The brother was trying to protect his employee, his sister's health, and ended up getting a lawsuit. So avoid those overly paternalistic approaches. Let employees come to you before you try to do something to help them. I guess let me stop there and we'll take questions as we move forward.
Okay. Real quick question, Tom. Can you explain the additional unemployment on top of the state unemployment? Do you mean they get an additional $600? Or Michelle or Carrie?
Yeah, that's a great question. And we keep waiting for somebody to tell us, to wake us up and tell us that it's not $600 on top of the state benefit. But the statute is very carefully written to say that if an employee qualifies for benefits under the state law, the state must pay them those benefits, can't reduce them, but must pay them those benefits. And on top of that, the pandemic unemployment supplement will be paid as well. This is going to result in a sizable number of folks getting more money while they're laid off than they're making while they work. And we originally thought they could not have possibly meant that. But as you go back and you read some of the committee reports, the House Ways and Means report, there's a Senate report, they all recognize that this is going to happen, but they did it anyway. Your employees, our businesses employees, are figuring that out. The employees are now trying to find ways to get off of work and to go home and sit for up to 39 weeks, receiving more money than if they had been at work. It's also going to create a problem when you do engage in layoffs, because you're going to send folks home and they'll make more money than the person who you retained to work a full week. So there's going to be a lot of difficulties with this. And again, we're already seeing it. People are learning the that this is out there, this problem is out there, and it's going to spread like a virus within your workforce.
What about the unemployment for the self-employed on the 1099 as far as the 600?
You know, frankly, I haven't looked at that. Michelle, Carrie, either one of you help?
I started looking at it. I couldn't get a clear picture from the statute what the amount would be, just that they could qualify. And I think we have to, it didn't say flat out $600 like it did in the other section. So I think that it remains to be seen what amount they're going to qualify for, but there is a way for them to get some assistance, yes.
That's my favorite phrase right now. It remains to be seen.
I've learned to say it about 10 different ways.
Yeah,
So.
clients don't really like it.
And for those with employees under 50 or under 50 employees, you can waive having to pay for the 2 weeks of sick pay. Is that correct?
Well, not necessarily. You've got to be able to establish that your business is in jeopardy if you want to opt out of the paid sick leave. And the regulations that came out yesterday set forth some specific criteria. I can't spit them back to you. I saw them about 2:30 this morning. But they do spend a few pages talking about what the specific criteria that you have to establish in order to opt out. And even if you opt out, it won't be a permanent opt out. It will be, you can only opt out for the duration of the time in which you are experiencing an emergency. So you may right now not be in an emergency situation and have to grant paid time off, but as your orders dry up, as your clients stop paying you, you may find yourself in an emergency and be able to refuse to grant the leave to some of your employees. 2 weeks later, you may have to make a different decision and grant it. It's going to be very difficult, but at least we do have, I think it's a 3 bullet point set of factors to evaluate in determining when you can opt out.
Okay. All right. Thank you, Tom. And with that, we're going to go over to Dr. Janelle Whitmer with our very own College of Business and Innovation at the University of Toledo.
Thanks, Angie, and good morning to everybody. I'm going to drastically switch gears here. I'm not a lawyer. I am an industrial organizational psychologist. So I teach human resources and I teach leadership in the College of Business at the university. And I also sit on the advisory board for the Family Business Center. Some of you, I thought I saw Dan in there, and Angie, of course, have gone through a leadership course with me. So I do externally from the university, but also within the university, leadership development, training, executive coaching, those types of things. So my main area of expertise and why Angie asked me to be on the call this morning was mainly from a leadership perspective. So leading remotely. When we started moving towards having remote employees, I started getting an absolute tidal wave of emails and calls from people, clients, people I do executive coaching with, just about, okay, what should I do? How should I lead remotely? What should the expectations be, etc. I think that Angie has disseminated pretty well, and it was on the LinkedIn, the Family Business LinkedIn site, a short article that I wrote from Angie's request, just because she had also received so many emails and questions about leading remotely. So I won't reiterate that article, but I strongly suggest that you read it if you have questions, because it'll go into more detail. But really, it's not from a technical aspect. I can't tell you any do's and don'ts with leading remotely. The main thing that I can tell you is that you need to be very clear about expectations. And I can't emphasize this enough. This is not, these are not your expectations as a leader. These have to be joint expectations between you and your individual employees. We have people who have children at home who are trying to, I'm gonna air quote, homeschool their children. I myself have an almost 10-year-old, a 7-year-old, and a 5-year-old. So right now I am locked in the basement hoping that they don't make too much noise. or the dog or the cats or anyone else. But this isn't business as usual. So we have to take into consideration the individual needs of employees. So leading one person is not going to be the same as leading another person remotely. So I strongly suggest, if you are leading people remotely, that you have a very frank and direct conversation with them. Be open. You've never been through this before. They've never been through this before. So what do they need from you? What would make their working remotely go as efficiently and as smoothly as possible and be as effective as possible? I talked about in the article, if they do have kids at home, or maybe just based upon personal preference, maybe they would prefer to be working in the evening or, you know, later into the night. Maybe this is an opportunity for them to, you know, be with their children during the day, get other things done during the day. I was actually just talked to someone who I'm do executive coaching with yesterday about the fact that he is firmly feeling the sandwich generation effect. And that is something that we are definitely seeing more and more as people have the full responsibility of maybe taking care of elderly parents. You know, their parents cannot, or even older parents, their parents can't leave the house, shouldn't be leaving the house. So they feel the need to go and take care of them, go do grocery shopping for them, do whatever they can for them, but also have to be at home to take care of kids, but also have to be employees and be available, you know, throughout the day. I was talking to someone the other day about the fact that her boss took this as an opportunity of, well, you're trapped at home and you have nothing else to do. So let me give you more work to do. And let me expect that you're going to be able to be available for phone calls at any point in time during the day and well into the evening as well. I think that that would be unfair to employees. I think that that would be realistic for employees. And frankly, while we are all at home and you all may be in pajama bottoms right now, we are definitely not unbusy, right? People are definitely feeling stress and feeling more pressure than maybe on a regular circumstances, excuse me. So definitely have a conversation with your employees about what the expectations are for individual employees. Don't make an across the board expectation of everyone is going to do this and everyone is going to meet at this certain time. If there's a drastic need for you to have daily or even weekly meetings, make sure that you are kind of surveying the employees to find out when would be a good time. The expectation that everybody's going to be able to get up and get ready and have their kids hidden away at 8 o'clock in the morning just may not be realistic for everybody. So, and are those things needed? Unfortunately, I've talked to many people who want to stay connected with their employees. So there's an expectation that every single day they're going to have one of these Zoom meetings. They're going to have some kind of video and we're going to be able to see each other face to face. And frankly, that can be a very large burden on someone who's just trying to balance all of their work right now. So really ask yourself, if you're leading remotely, is that in fact necessary? Is it better to have individual phone calls or a conference call where people don't have to be on video? But again, that's going to be individually based. How much and how frequently do we need to do that? Of course, that's going to be on a business case-by-case basis. Angie told me yesterday that she's really enjoying these Zoom meetings and these face-to-face meetings because she's more extroverted, and frankly, I enjoy them too, so I can see everybody and I can talk to everybody. But this may not be a comfortable setting for people to perform, and maybe they prefer not to have these types of meetings. So again, it's a personal preference thing, and we have to really know our employees. As far as micromanaging goes, we have to be very, very careful during these times how we word things with our employees. We want to make sure that we are there and we are available for them, but we do not want to appear like we are micromanaging them from a distance. Again, people have personal pressures and different circumstances at home. So I would encourage people to word things like, how are you doing? Is there anything that I can do for you? Rather than what's going on, update me on this, constant updates, and, you know, kind of grilling them on what they're accomplishing. It's just a simple wording difference, but it can really make all the difference in the world if we're just there more as a servant leader asking what we can do for them rather than asking them for the checklist of things that they've accomplished for the day or the week. Along those same lines, I would encourage you to really have a discussion about expectations, when people can accomplish things. Things that used to be done daily in a 9-to-5 work setting, maybe those are now weekly goals. Perhaps people want to work in larger chunks. For example, my husband is still working outside of the house. And so there are days like tomorrow, he will not be working. He's going to be doing full-time school with the kids so that I can full-time work tomorrow. So I plan on working probably 12 or 13 hours tomorrow, whereas today I might be only working 4 hours. So can we balance our expectations and our goals on a weekly basis or even longer than that, just to meet the employees' needs? One of the other questions that I've received from a lot of people, because what I work with is their personal development, their personal leadership development, can we still expect employees to be taking part in webinars? Can we still expect employees to be engaging in personal development and, you know, doing things to increase their knowledge, skills, and abilities at that point in time? Again, this has to be individually based. I was working with one firm last week. I had just started working with them, and I kind of thought to myself, maybe this isn't the best time to be, you know, starting to work with people. I've only met with most of the people only once, just kind of a quick introduction meeting. And so I had maybe mistakenly sent them an email and thought maybe this should wait. Maybe our work together with this firm should wait. And they actually emailed me back and they said, this is a really good time for us. We may have to meet remotely, we may have to talk over the phone, but it's actually a really good time for us to press the pause button and start thinking about doing things differently. And they're absolutely right. So this may be a good time for people to focus on their personal development, but it may not be. So again, that has to be something that you speak with employees individually. I've done a lot of my executive coaching via phone, but then I've had other clients say, you know what, I'm too busy and I'm too stressed and there's too much anxiety right now, and I'd really rather meet with you face to face when all this calms down. And so obviously I have to respect that. So the main overall theme I can say with leading remotely is that it just has to be based upon individual needs and not to make any kind of sweeping or overarching policies or procedures for all of your employees. Try to really focus on them as an individual.
Thank you, Janelle. Before I pass it off to Mike, I have one quick question on that topic.
Yep.
Maybe our lawyers might need to chime in on this one, but if you allow some employees to work remote, are there any legal issues because you're not providing an opportunity to everyone? Whereas some positions you physically need to be there and you would maybe have to lay them off, but some you can allow them to work remotely.
It's a great question that we're getting quite frequently. Why can't I telework? You know, Amy in Human Resources can telework. Why can't I, I'm a quality manager? Well, there are some jobs that still have to be physically performed on site. And, you know, employers were encouraged with the stay-at-home order to look at their workforce and determine which functions could be performed remotely and let employees perform those functions remotely. We've been very careful to communicate with employees so, you know, we don't have an entire workforce who wants to stay working remotely when this pandemic is over, that this is a temporary change in the way we're going to run business. And you might not be able to perform all of the essential functions of your job, but we're going to permit you temporarily to work remotely. You can have the same type of conversations with employees like we had to have with the quality manager who also wanted to work from home. Because his job was to supervise employees and the final quality of product, that was not a viable option. And he didn't have any medical reason or need that would make the employer have to consider whether telework or other work arrangements would be an accommodation for any sort of disability issue. So yes, if you need someone to be physically present, to do your payroll or to answer the phone or to get the mail, you can have them be physically present. It may be appropriate because of social distancing to change the times and to stagger the times in which employees will be physically present at work. But there are still some jobs, if you're an essential business, that require people to be physically on site at work, where telework is not going to be an option for them and can be denied.
Thank you. And with that, I will pass it over to Mike Hamp with the William Bond Company.
Thank you, Angie. Good morning, everybody. So we're going to shift gears maybe a little bit again. So we've gone through a bunch of legal suggestions and advice. We've got remote leading. And then what I'm going to talk about here, at least what I've spent the last several days talking about, is this Paycheck Protection Program, Section 7A. And if that doesn't apply, if that doesn't make sense, what other options might a company have? Might the 7B program work, or might some of the other provisions in there? So let me just give a brief summary, and I apologize for those of you who already dove deep into this, but let me just give a brief summary as far as the intention of this Paycheck Protection Program. And really what it's meant to do is really in theme, or in coordination with the same theme as the others. It's just trying to keep people at work, trying to keep a paycheck in their hand, and trying to supplement the cash flow of the employer to be able to keep that paycheck in their hand. So as we go through here, I'll kind of preface in the beginning to say there's two kind of numbers to kind of keep in mind. One number is how do you calculate how much I can borrow, which is independent from a calculation of how much is going to be forgiven. So I think most of the confusion comes in is when we try and kind of combine those two into the same sentence or the same thought. And they're just simply two different concepts. But first you have to determine, are you an eligible entity? The number out there is 500 employees. And so you get a lot of people talking about the 500 employees. One of the things that we want to make sure that we're stressing is there's a thing called an SBA size standard. And so if you look at your NAICS code and you go to the SBA website, they're going to have a chart that will be by all the NAICS codes. And if for your size standard, there is not a employee head count next to your code, there's a revenue number, then the default answer is 500. If there is a number next to you, it's not 500 that applies, it's whatever number that is. For our neck of the woods, the most important fact there, most manufacturing NAICS codes, it's actually 1,000 versus 500. So if you're a larger company, if you're advising somebody and they say, I don't qualify because I'm over 500, just encourage them to pause for a minute and make sure that they're looking at those size standards to make sure that their NAICS code doesn't have something specific to that. So once you say, okay, so I am a company that does qualify, then you go to, okay, so how much is it that I can borrow? The calculation is essentially when you go to the bank and you submit the paperwork, you're going to calculate your average monthly payroll for the last 12 months. That's kind of as simple as the guidance says. We believe that, let's say we go to a bank tomorrow and we have March closed, right? It literally is going to be March. If for whatever reason a company doesn't have March closed, well then just calculate the 12-month average for the 12 months ended February 28th, or I guess February 29th of this year. So it's pretty straightforward. You take 12 months of payroll, you have your average amount, you multiply that by 2.5. A couple of nuances in calculation. If you are a seasonal employer, there is some specific provisions that you don't have to use all 12 months. You can go back and kind of use more of a seasonal time frame. And then also kind of what is payroll? So it's not only the salary and wage and compensation, it's also one-time incentives such as bonuses. It's also retirement pay. So if you have a 401k match, it's also the state unemployment payments. So there's a list out there that basically the payroll cost is a little bit of a larger number than what people might assume on the surface. So you take all your payroll costs, have the monthly average, multiply that by 2.5. There's a haircut for individuals whose amount of payroll per individual is over 100,000. And so there's a little confusion there. A lot of people have asked, So does that mean if somebody makes over 100,000, I have to exclude them from my average payroll? You do not exclude them from the average payroll. You simply only include $100,000 for that person. The other confusion that I've seen out there that I think is still a little bit confusing is if somebody makes $100,000 and gets $10,000 of benefits, is the number 110 in my calculation, or is it 100? The conservative approach is it's 100, because the way the code reads is payroll cost is limited to 100,000, and then they say, well, payroll cost includes benefits. So inherently you'd say, okay, well, it must be 100,000 is the cap, period. That is a literal reading. Personally, I'm not 100% convinced that that's really what the intent was. So there's a little bit of confusion that we might be getting some clarity as far as this $100,000 cap. So we calculate the 2.5 times, let's say we have a $100,000 payroll, average monthly payroll, 2.5 times that. So we're going to apply for a loan for $250,000. And let's say that the banks open up tomorrow, we apply the loan. By the time we get funded, we're finally funded the money 2 weeks from now. So Monday, April 20th, we have $250,000 that is given to us. So then it says, okay, well, what do I do? How much, what can I use those expenses for? And basically what you can use them for is the payroll cost. So those same costs that you use to develop your average monthly cost, but then you can also use it for payments for your mortgage. You can also use it for payments for pre-existing debt. You can use it for rent. You can use it for the utilities. There's a little bit of confusion as it relates to this pre-existing debt, because while you can use the funds for payments on pre-existing debt, the payments that you're doing for pre-existing debt is not included in the forgiveness calculation. So pre-existing debt included on the permissible uses, but it's not included in the forgiveness calculation. So we have our $250,000. It's Monday, April 20th. The way the forgiveness calculation works, so keep in mind, average monthly payroll 2.5 times, that's calculations done. Now we're on to the second calculation. So it's Monday, April 20th. It's for the next 8 weeks. We're going to track 4 different categories. We're going to track all the payroll costs, once again, just the same way that we calculated it. Track the interest that we're paying on any mortgage. So this is a real estate-based mortgage. Rent and leases, once again, that's on real estate. Rent and leases on real estate, and all of our utilities. So for the next 8 weeks, we're going to accumulate everything we're paying in those 4 categories. That is what our eligible forgiveness amount is. If we borrow $250,000 over those 8 weeks, we incur $200,000 of expenses. That's our eligible expense. There's another layer to the story. We need to look at our head count, and this is an actual FTE calculation. Need to look at our FTEs during that 8-week period compared to the previous year. And if we have 100% of the folks still on the payroll, then we get 100% of the forgiveness. If we have 80% of the people on the payroll, we get 80% of the forgiveness. There's also a caveat within the rules that even if we have the head count, but we've just reduced everybody's pay, once we reduce everybody's pay by more than 25%, there's also a haircut on the forgiveness. So 2.5 times average monthly pay, that's what we're able to borrow. Then we go through this 8-week calculation, and that's the forgiveness amount, or at least the eligible amount. And then we go through this kind of, do we have the same head count? Do we have the same compensation levels? And that determines a percentage, and so we get that percentage of the forgiveness. Right now, the 8-week period as written starts on the origination date of the loan. There is some discussion, so that's not ambiguous right now. It's very clear. It starts on the origination date. But there is some discussion out there that they're trying to get the rule modified such that an employer could choose to start the 8-week clock at any point up to June 30th. So the intention here would be, there's just concern that the money is going to run out. And so we apply on Friday, we get funded on April 20th. We're in Ohio here. We're not even going to be back to work until May 1. So my 8 weeks is starting during a time period where I'm going to have reduced cost. And so my forgiveness isn't going to be as high as it otherwise would. So if my industry, if my particular business, if I'm able to come back online as of May 1st, why am I put in a spot where I need to delay my application, risk the money being gone by the time I put my application in, just because I'm not going to have the expenses during this 8-week time that I would have otherwise had. That's kind of the rationale for them trying to adjust when the 8-week clock starts ticking. But that's just a discussion right now. Nothing has actually been, I guess, formalized as far as changing that. So that's an overview as it relates specifically to this Paycheck Protection Program, 7A, as it were, within the SBA. And open up questions.
Thank you, Mike. Few questions. So what about workers' comp and federal unemployment? Are those payroll costs that would be forgivable under PPP?
No, I do not believe that those are. Those, the withholdings for the unemployment, the federal withholdings are not included. It's the state and local withholdings that are included.
Okay. And can you confirm that independent contractors are not included in the payroll calculations that they file?
Independent contractors are included. You must issue a 1099 to them. So your payroll cost is individuals that you've given W-2s plus the benefits to them, and individuals that you've given a 1099. So that's an excellent point. In your payroll cost, independent contractors issued a 1099 are included.
Okay. For the PPP loan, is required minimum contributions to a defined benefit plan included as payroll calculation?
You're saying from a self-employed standpoint, huh? Because from an employer standpoint, it's really not a cost of the employer.
Yeah, so from a self-employed standpoint?
Yeah, that doesn't really run through the actual business. I don't know if anybody else has any take on that, but I don't believe that that's.
It's been our position that all standard, usual, however you want to term it, contributions to any retirement plan, because I don't believe that there's any breakout of that in the guidance we've gotten.
I think I'm actually misreading this. I mean, sorry, Wyatt. I was thinking that you're talking about the required minimum distributions. You're talking about required minimum. If it's
contributions.
If it's an employer contribution, yes, it is included.
Yeah.
Okay, so hold on, I have a lot of questions here on this topic. Let's see. So if you fill out the application and it asks for a number of employees for 7A, should that just be full-time equivalent, or should that be full-time plus part-time? 7A.
So the 7A has two different numbers to it. One is the 500 that says that you're eligible. And is, do you have a reduction in FTEs, which is the calculation for how much is forgiven. So on the application, that is the original, the 500 person, that is the SBA. It's basically the SBA regulations are dictating what an employee is, and it's really meant to be a belly button thing. So a part-time employee is one employee.
Okay. Is there a document that defines what's included and what's not included in the PPP payroll calculation?
Yeah, the U.S. Chamber of Commerce has an excellent 4-page summary that basically will go through the payroll costs that are included. And so it's salary, wage, commission, similar compensation, payments of cash tip, if that's common in your industry, payment of vacation, parental, family, medical, or sick leave, allowance for dismissal or separation. So if you had somebody that separated from you in the last year and you gave them a severance pay, payments required for provisions of group health care benefits, including the insurance premiums, payments of any retirement benefit. So to the question earlier, as long as it's an employer contribution into a plan, it is included. And then payment of state or local taxes assessed on the compensation of the employee. So that's the comprehensive list of what is included. And then the what's excluded is this comp in excess of 100,000. the kind of the actual payroll, the income taxes, also compensation if you do happen to have employees that are working outside of the U.S. You have to exclude that. And then if you're paying people under the Family First Coronavirus Response Act, so it's mandatory sick pay, or the FMLA, if you're paying folks under that, that gets excluded also.
Okay, did it reference other payroll taxes like or 401k match contributions or healthcare contributions?
So the healthcare would be in the healthcare benefits, and the 401k match would be in that retirement benefit. So those would both be included.
Okay. Okay. Can you repeat, someone had asked, can you repeat the 4 categories that need to be tracked?
Sure. So if you have a mortgage on the interest on that mortgage, if you're leasing the building, it's the rent, the lease on that building. So payroll, including benefits, plus your occupancy, plus the utilities is the 4 categories for that 8-week period of time.
Okay. So here's kind of a calculation question. So if I calculate my payroll at 2.5 times and I can borrow 25,000, but then I track payroll, lease, rent, utilities, and that exceeds the 25,000 greatly as I'm including in the lease, rent, utilities. Can you borrow more than 25? So
No,
okay.
no, under 7A, you're capped at 2.5 times your average payroll. Now there is, I kind of mentioned earlier, let me get to the actual date here. There is, if you're seasonal, you can go back and, as opposed to using the entire 12-month average, you can go back to a February 15th, 2019 and go 12 weeks forward from February 15th, 2019. If for whatever reason for this particular business, it makes more sense to start the clock at March 1st, 19, you can also do that. So you can do March 1st, 19 through June 30th, 19 as one window of time. Second window of time is February 15th for 12 weeks forward. Second window of time. You can go back and calculate both of those. And if your average is higher in those periods, then you can do 2.5 times that average. But just because the occupancy cost or the utilities are exceptionally high, it does not increase the maximum amount that you can get under the 7A.
Okay. So someone asked if, as an employer, can they receive unemployment? They might make.
They get the 7A. Yeah. So your compensation can absolutely be included in that payroll, even if you're not. So like an S corp, you'd actually get a W-2. That's a little bit more intuitive. Even if you're just a sole proprietor, an LLC, and you have guaranteed payments, anything that is subject to the self-employment tax. So I think what they're going to do. So there's a little bit lack of guidance in this exact area. What we believe that they're going to do is they're going to go back in history a little bit as far as if they're really trying to challenge somebody and say, well, how much of your income was subject to self-employment tax? That's going to be a quote unquote reasonable amount, but also keep in mind that the compensation that you can use to calculate your average to get your 2.5 and the compensation that you can use to calculate the forgiveness is capped at the $100,000. So if you were making more than $100,000 as a self-employed individual, we believe that you can absolutely include $100,000 in both calculations.
Okay, thank you. All right, I have a rather long question I'm going to read here to you. Unemployment, we might have covered this for self-employed sole proprietor, ones who never took a paycheck. So this is maybe uncharted water. There are many small businesses that operate in a perpetual hand to mouth model. They work when there's customers. They cover obligations and expenses, and what is remaining is their income. The general consensus of the definition of income is by using a form Schedule C as the final reporting of income on Form 1040. And this is in the notes if I'm not clarifying it.
Yep.
If a self-employed person completes some work during the period of unemployment, but doesn't have income because expenses are greater, is there unemployment? Is the self-employed sole practitioner only employed once they cross back to earning an income after the expenses? Does that make sense?
So I feel like where the question is going, can I be somewhat self-employed at the same time that I'm unemployed?
And that question is from Bob. And if you're still here, feel free to unmute and jump on and clarify that.
Where I would be a little confused here is that for the attorneys that are here, from an unemployment standpoint, I would think that if you're self-employed and you have income, wouldn't that then disqualify you from getting unemployment?
Hey, this is Bob. I'm here. Okay. I'm a photographer. So my income comes from photographing events, weddings, and such. Someone wants to buy a 5x7 for $12. If I take the $12 in, which nowhere near covers my expenses, am I now employed again? Or do they tell them to take a hike until it's over?
Yeah, I think that's more of an unemployment
Yeah,
question.
Bob, I would say, normally I think all bets are off is what I would say. I don't know how else to say it. I think they're going to interpret things broadly where they wouldn't in the past. In my opinion, if I were in your shoes, I would file for unemployment. I would file those weekly claims. Whatever income you have could be approved and your income would just be an offset and you'd still get the remaining amount, or they may not even consider it. In the CARES Act, the stimulus bill, there's an additional pandemic assistance for self-employed people. They haven't said what that amount is, but for people who don't traditionally qualify for unemployment or have exhausted it, there's going to be some form of unemployment. So I'm just telling people, look, let the state sort it out, apply for everything, apply for unemployment, and see where you get. I mean, there's no doubt your business has been in a downturn. So I actually had this debate on Facebook of all places with an accountant, because an accountant was saying, well, if you didn't pay into payroll for yourself as a self-employed person, you won't get unemployment. I don't think that's as clear as the accountant is stating it, because there are statutes in the Ohio Revised Code, in the definition of employer, and in the administrative regulation that says a self-employed person or an officer of a corporation can elect to be covered even if they're not. Now, I'm not sure if that election is going to be retroactive or not, and the Ohio Department of Job and Family Services has kind of gone back and forth in the Q&A as to whether self-employed people qualify, but I feel like this is enough of a moving target that you might as well apply. And I see Tom is itching to jump in, so if you have an answer.
I'm just going to direct Bob to the Jobs and Family Services website. They've got the Q&As for the coronavirus issues. And question 10 specifically addresses it, at least from the Jobs and Family Services perspective. And they're going to tell you in that Q&A right now that self-employed individuals aren't covered, but that DeWine has asked for a federal declaration that would allow assistance to be extended to you. So I would bookmark that website with the Q&As and check it on a daily basis, because you will see constantly those Q&As are updated, and they'll put an update in red. And so you can watch for when that program may be approved. I agree, by the way, that you should still make the effort. Just go ahead and apply and let them tell you no.
Yeah. And that Q&A has changed, because they used to say what I'm telling you, that you may or may not apply depending on your structure and what you've paid in. So it's a completely moving target. Don't risk it, just file.
I've been watching that site and trying to figure out also on the loan, because those of us who operate like very, very small businesses haven't structured ourselves to writing paychecks weekly, because there may not be money weekly when you run these tiny businesses.
Yeah, but for the 7A, I don't think the paycheck is what the trigger is going to be. I do think whether it runs through a traditional payroll or whether it's self-employed income, I think the trigger is going to be, did you pay self-employment tax on that? So if on your 1040 you have Schedule C income, it's likely subject to self-employment tax. So my reading of at least the 7A, that would be when you calculate your 2.5 month average, and then you calculate your forgiveness during that 8 weeks. Items that run through Schedule C and are subject to self-employed income tax would be payroll cost per the 7A calculation.
And then you add your 1099s on top of that.
Correct. Yep.
Got it. Thanks, guys.
Yep.
Okay, I have a question here. If you're drawing a Social Security as a business owner, do you qualify?
I don't think drawing the Social Security disqualifies you. If we're talking specifically the 7A, we would have to have something that qualified as payroll cost to multiply by the 2.5 to kind of start the calculation rolling. So if we had self-employed income that was subject to self-employment tax, if we were paying other people W-2s, or if we had 1099 independent contractors, any and all of that would get grouped together in the payroll cost. So the Social Security doesn't preclude the 7A, but you have to have payroll cost to multiply by the 2.5 to start the ball rolling.
So if your business has been negatively impacted by this pandemic, is there any reason why you wouldn't apply for a loan under 7A?
So there are businesses that just don't have employees, don't have payroll. We've run some math for a very unique situation for a business that had 3 employees. So this is the 7A program. In the first wave, first phase, I should say, of all the different acts, phase 1 that came out on March 6th, embedded in that one was called the Economic Injury Disaster Loan, EIDL. So the EIDL does not have the same forgiveness provisions that the Paycheck Protection one. So if you have payroll, then the point's well taken. The Paycheck Protection Program appears to be just a no-brainer to get the paperwork going and go apply for that. But if you're a business, let's just say that you own some rental properties and you're concerned about tenants not being able to pay the rent, or you're concerned about the value of that property significantly being reduced over a period of time. Then you can go to the SBA, file the paperwork for what's called 7B, this EIDL. The EIDL is an actual loan, 3.75% interest, 30-year term. So we're really not advising the notion of, if you're fearful of economic harm, to kind of necessarily go down the whole EIDL process and getting a loan. But as part of the application, there's a $10,000 grant. So if you don't have payroll, then the 7A is not going to make sense just because you don't have any payroll costs to start the ball rolling. We're advising folks to go check out the 7B. Both of them are right on the front page of the SBA's website. Go down the path of the 7B, and the $10,000 grant is per the website. I have not talked to an individual that's actually got the check yet. But per the website, you're supposed to get the $10,000 within 3 days. The $10,000 is not owed back if you are denied the 7B program. It essentially is kind of free money. The 7A, the loan forgiveness, it is very, very unusual for the IRS to do this, but the loan forgiveness is not taxable income to the company. On the 7B, this $10,000, we believe that it's going to be not taxable, kind of treated the same way that the 7A forgiveness is. But while 7A, it explicitly states that it is not taxable, 7B with this $10,000 isn't quite as clear. So if you have payroll cost in that 2.5 times the payroll cost is $15,000, $20,000, $30,000 plus, then absolutely our belief is a 7A program is a no-brainer. Money could dry up quick. Make sure to call your bank and get that paperwork going as fast as possible. Maybe one other kind of nuance, I guess clarifying point, is both 7A and 7B. So let's talk about the 7B being that's $10,000 grant. It can be more, but that's kind of the focal point. The 7A is the Paycheck Protection. Both of them are SBA loans, but the SBA is not going to be able to just deal with the volume of loans under this Paycheck Protection. So they've enlisted the banking community to be the agents to disperse the funds. So while both are SBA funds, you need to go to your bank to get the Paycheck Protection Program, versus the bank is not involved at all in this $10,000 grant. You go straight to the SBA website to get the 7B Economic Injury Disaster Loan, EIDL, and this $10,000 grant.
Okay, thank you. I have time for one, maybe two more questions. Are 1099 contractors also entitled to the additional $600 per week? Or anyone?
Michelle, you're still on mute.
All right. I would say they're entitled to an additional amount. I don't know that it is going to be 600 per week. I don't think that was spelled out in the statute, and we don't have any regulations yet. So they are entitled to something, but I don't know what the amount is.
Okay. Okay, and that takes us to 10. I know I had some additional questions, but I know people have other commitments after this. So we did record this. We will post it and put it online. Maybe if you had additional questions or needed clarification, take maybe another review. And if you find your question wasn't answered, email it to me and I will email the panelists and get that answer for you. I thank you so much. We really appreciate your time. I know everyone's really busy and moving really fast to try to make sense of everything that's happening here. We really appreciate all of our sponsors, everyone jumping online and participating. And with that, I think that's it. Thank you. Thanks for coming. And we will, if we find these are helpful, we'll send an email with the links that we talked about, the ones that we can find, the link to this video. And if you have any feedback for us on how we could maybe improve on this process, we're new to this too, although we're starting to really love Zoom. But this is all we've had to pivot as well. And what the center does best is try to connect people together. Many of our sponsors have been with us since the very beginning, and they're trusted advisors. And I think a lot of members are finding that they're very appreciative of all the expertise and the content and the help that our sponsors are providing them. But we will certainly get all that information out to you. Let us know any feedback you have. And if you find this is helpful, and if our sponsors and our experts, our faculty are willing, we will do as many of these as we can to try to help get information to you and clarify everything. Okay, so thank you.